5 seconds to go. Start. Section 313 CRPC, Clause B of subsection 1 is a valuable safeguard in the trial process for the accused to establish his innocence. Section 313, which is intended to ensure a direct dialogue between the court and the accused, casts a mandatory duty on the court to question the accused generally on the case for the purpose of enabling him to personally explain any circumstances appearing in the evidence against him. When questioned, the accused may not admit his involvement at all and choose to flatly deny or outrightly repudiate whatever is put to him by the court. The accused may even admit or own incriminating circumstances adduced against him to adopt legally recognized defenses. An accused can make a statement without fear of being cross-examined by the prosecution or the latter having any right to cross-examine him. The explanations that an accused may furnish cannot be considered in isolation but has to be considered in conjunction with the evidence adduced by the prosecution, and therefore no conviction can be premised solely on the basis of the section 313 statements. Statements of the accused in course of examination under section 313, since not on oath, do not constitute evidence under section 3 of the Evidence Act, yet the answers given are relevant for finding the truth and examining the veracity of the prosecution case. Statements of the accused cannot be dissected to rely on the inculpatory part and ignore the exculpatory part, and have to be read in the whole inter alia to test the authenticity of the exculpatory nature of admission, and if the accused takes a defense and proffers any alternate version of events or interpretation, the court has to carefully analyze and consider his statements. Any failure to consider the accused's explanation of incriminating circumstances in a given case may vitiate the trial and or endanger the conviction. Bearing the above well-settled principles in mind, every criminal court proceeding under Clause B of subsection 1 of section 313 has to shoulder the onerous responsibility of scanning the evidence after the prosecution closes its case to trace the incriminating circumstances in the evidence against the accused and to prepare relevant questions to extend opportunity to the accused to explain any such circumstance in the evidence that could be used against him. Prior to the amendment of section 313 in 2009, the courts alone had to perform this task. Instances of interference with convictions by courts of appeal on the ground of failure of the trial court to frame relevant questions and to put the same to the accused were not rare. For toning up the criminal justice system and ensuring a fair and speedy trial with emphasis on cutting down delays, the Parliament amended section 313 in 2009 and inserted subsection 5, thereby enabling the court to take the assistance of the public prosecutor and defense counsel in preparing such questions, the first part of subsection 5. Ideally, with such assistance, which has to be real and not sham to make the effort effective and meaningful. One would tend to believe that the courts probably are now better equipped to diligently prepare the relevant questions lest there be any infirmity. However, judicial experience had shown that more often than not, the time and effort behind such an exercise put in by the trial court does not achieve the desired result. This is because either the accused elects to come forward with evasive denials or answers questions with stereotypes like false, I do not know, incorrect, etc. Many a time this does more harm. Stop.